And we're all supposed to yawn that the CIA is coordinating with Clinton operatives to try to target the sitting president at the time. No wonder no one trusts them. I saw Hillary in the news the other day. She's out there running. I don't know, she's not running for anything, but she's clearly interested in still influencing politics. So anyway, she's out there, and she was at the state dinner at the White House the other day with her husband, Bill Clinton, for the Prime Minister of Japan. And I noted online that, the disgraced politicians, Bill and Hillary Clinton, Bill, who was impeached, disbarred, and barely escaped prosecution. Hillary similarly escaped prosecution twice, protected by the deep state and or, as I call it, the loser Republicans, who are afraid to pursue justice against Hillary. And of course, they're happily over at the Biden White House. Kind of a dramatic illustration of just how it shows that crime pays for the elitist left in this country. And but Judicial Watch isn't giving up on the corruption targeting Trump, pursued by Clinton. When we talk about the spying against Trump, when we talk about the spying against the Trump campaign, that was in league with the FBI working hand in glove with the Clinton campaign. And then even after he was elected, you had Clinton operatives, her campaign lawyer, communicating with the FBI and CIA, trying to get them successfully in some measure to go after Trump. And one of those lawyers was prosecuted. The Clinton campaign lawyer Mr. Sussmann, you may recall, was unsuccessfully prosecuted by Special Counsel John Durham for making a false statement to a federal agent about who he was representing when he went and tried to get the general counsel for the FBI to investigate Donald Trump's computers, because they were, they had concocted this idea that the Russians were somehow involved with his computers. Just like really crazy conspiratorial stuff. Obviously false. But in Sussmann's trial and in the Durham Report, it came out that the FBI, the CIA, had talked to the Clinton campaign lawyer. And we sued for those records back in 2022, excuse me. Our request was back in 2021. And we had a court hearing on it, because the CIA is just playing games with us in terms of responding to our request for this basic information. What was going on in the CIA with respect to this Clinton operative? During the hearing, this court hearing we had before, I think it was before Judge Walton, who's a federal judge here in the District of Columbia, Judicial Watch explained that the case was filed more than 2 years ago, and that it took the CIA more than a year, until July 1st, 2023, to provide 4 responsive records introduced into evidence at Sussmann's spring 2022 criminal trial. So these were essentially government public documents. And even then, they had these ridiculous redactions. Let me see if I can find them for you. Yeah, redactions of what they were told by this private person, this lawyer. Here, let me show it to you. So these are what the redactions look like. Some agencies use white rather than black. They've gotten figured out that it doesn't look good to have black redactions. This is not CIA material. This is Clinton campaign material, or Clinton campaign lawyer material. I guess there's a debate about who he was representing, the Clinton campaign or the tech people who were working essentially with and for the Clinton campaign. So we've been involved in this case for years just to get this basic information. And our top lawyer, Paul Orphanides, who directs our litigation team. He was in court this week with Judge Walton. And he filed an excellent brief, I guess it was last year. But they've been stalling. And, you know, I kind of want to go through this with you because we're taking on the darn CIA to figure out if they were trying to interfere in our, no, not interfere in the election. I think it was this post-election. When was this meeting? Yeah, it was during the Trump administration. The CIA is meeting with folks trying to get the CIA to spy on and target Trump. It's called sedition, right? Is that insurrection? So forgive me for thinking it's still important. We're talking about domestic spying a lot this week with FISA. I'll talk a little bit more about that in a minute. And we're all supposed to yawn that the CIA is coordinating with Clinton operatives to try to target the sitting president at the time. No wonder no one trusts them. You know, and Paul in the brief highlights how these redactions, these blackouts are so outrageous. And I encourage you to read the brief. It's linked in our press release. You can probably link it directly below. The memorandum is Chattison's work product, which Chattison was an outsider who was setting up this meeting, not the CIA's work product. If the CIA's work product, sometimes they can hide that from you for obvious reasons. The CIA's invocation of Exemption 1 over substantial portions of this memorandum fails to explain how disclosure of a record prepared by a private individual about a conversation with another private individual could properly be classified or otherwise said to contain information about intelligence activities and intelligence methods. So Exemption 1 is the exemption under FOIA that agencies can use to, they cite in order to justify the withholding of classified material generally. Nor does the defendant explain how or even why the two private parties to the conversation would be discussing or even know about the defendant's then current methods of communication or intelligence gathering capabilities or the travel destinations of the CIA officer or areas of interest for intelligence collection. So, I mean, we do this basic FOIA request, and the next thing you know, we're arguing national security issues with the CIA that they're trying to make classified communications from Hillary operatives to them. That's where we are right now. And then there's this other weirdness where the CIA is refusing to give us a list of documents they might have but are withholding, or even the number of documents that are at issue here. No list, no numbers, they're calling it. And that's very unusual in the FOIA context. I don't think I've ever run against, certainly I don't recall it ever happening in a Judicial Watch FOIA case before. We've had what they have called GLOMAR exceptions. You can look up the GLOMAR case for more information about that. It's a very interesting story. But the GLOMAR exception is we can't confirm or deny whether documents exist. And sometimes that's allowed, especially in the intelligence context, right? Now, think about why it might. I'll give you a second to think about it. Why might it be appropriate for an intelligence agency to say, we can't tell you if the documents exist or not? Because in some cases, you may have intelligence activities you don't want to confirm or deny to keep the bad guys and the targets of intelligence gathering, in the dark about it. In this case, they haven't gone that far, but they're suggesting those are kind of similar issues involved in not giving us the number of documents they have or providing us a Vaughn index. A Vaughn index is an index of documents which the agencies in FOIA cases, well, I don't know if it's only FOIA cases, but it's where I've run into it. In FOIA cases, supply to the court and to the party suing, where they disclose the records, they give some description of the records and the reasons and the justifications for the withholding. So they're kind of like Excel spreadsheets, more or less, right? And they don't want to provide that here. So this is the interesting case so I want to talk about that. No number, no list. Plaintiff recognizes that the missing records identified may be among the responsive records subject to defendant's no number, no list response. I guess there were some missing records that were referenced. Yeah, these missing records were records that were in the trial that were already known to be in the CIA's possession, it looks like. Little precedent exists regarding no number, no list responses. Most significantly, the court, in a prior case concerning the ACLU in another FOIA matter, expressed substantial caution about their use. No number, no list response might be viewed as a kind of Vaughan index, as I was describing earlier, albeit a radically minimalist one. Such a response would only be justified in unusual circumstances and only by a particularly persuasive affidavit, usually from an agency official who explains to the judge why they can't provide the information, in theory because of national security grounds. The court continued in this ACLU case, once an agency acknowledges that it has some responsive documents, there are a variety of forms that subsequent filings in the district court may take. A pure no number, no list response is one end of the continuum. A traditional Vaughan index is at the other. Not quite as minimalist as a pure no number, no list response might be a no number, no list response with respect to a limited category of documents coupled with a Vaughan index for the remainder. So you could have a mix. So, you may be kind of getting a little confused here. But I raised this issue with you to highlight how the CIA is playing games with us. So this is essentially an admission that there are a bunch of documents, but they're telling the court they don't want to tell us how many documents there are, even though there's a category of records that have been disclosed through this court process already, a criminal case, where the CIA was involved in dealing with this Clinton operative. And this is the conclusion from Paul's brief. The CIA's response to our request was woefully inadequate. The defendant admits I gotta go up here, it's easier for me to read. The CIA, I call it, it's the defendant, but the CIA admits it did not even search for records responsive to the request, but instead relied on an earlier search based on undisclosed parameters and produced only a handful of redacted exhibits introduced into evidence by the government at Sussmann's criminal trial. Its no number, no list response ignores the substantial information already made public at the criminal trial and in the Durham Report, and it is not supported by defendant's conclusory declaration. Defendant's redactions to the Chattison memo are neither logical nor plausible nor supported by defendant's declaration, especially because the memorandum memorializes a meeting between two private individuals. Defendant's motion for summary judgment, that's a motion basically to throw out our case, should be denied, and our cross motion should be granted. So we're seeking a cross motion that their case should be thrown out. We should get the documents. Defendant should be ordered to conduct a proper search, provide a Vaughan index of any additional responsive records located during that search, and produce an unredacted version of the Chattison memorandum consistent with plaintiff's arguments herein. So it tells you a little bit about the work we're doing here. I normally don't get into that level of detail about our FOIA cases, but I think it's worth highlighting. And again, to give you more context here from Paul's brief, this is from the Durham Report. Two CIA employees, CIA Employee 2 and CIA Employee 1, prepared a memorandum summarizing the meeting they had with Sussmann in February of 2017. The final version included Sussmann's representation that he was not representing any particular client. Remember, that was a big issue. He was prosecuted because he told the FBI, oh, I'm just here as a citizen. There's no, but in fact, Durham alleged he was there for Hillary. In their interviews with the office, those CIA employees specifically recalled Sussmann stating he was not representing a particular client. Indeed, the email suggests that as well. During the meeting, Sussmann provided 2 thumb drives and 4 paper documents that, according to Sussmann, supported the allegations. The CIA analyzed the allegations and data that Sussmann provided and provided a report to reflect its findings. So they were investigating Trump. CIA was investigating Trump at the request of this Clinton lawyer. The report, Trump, by the way, was president at the time. The report explained that the analysis was done to examine whether the material provided demonstrated technical plausibility of the following. Do linkages exist to any Russian foreign intelligence service? Do linkages exist to Alpha Bank, which is a Russian bank? Or are the provided documents data based upon open source tools activities, and is the provided information technically conceivable? The CIA ultimately concluded that the materials that Sussmann provided were neither technically plausible, nor did they withstand technical scrutiny, and further that none of the materials showed any linkage between the Trump campaign or Trump organization and any Russian foreign intelligence service or Alpha Bank. The report also noted that one of the thumb drives contained hidden data, which included Tech Company 2 Executive 1's name and email address, so they knew a little bit more about who had provided it. So that is the issue here. The CIA was investigating Trump, spying on him, right? At the behest of Hillary Inc. So they didn't really want to search for records. We forced them to search for records. They gave us documents that are obviously only a part of the records. I mean, we talked about the thumb drives and the documents that were given to them. There's no records reflecting that were turned over to us or even listed in a log of documents they're not giving to us. And as I say, the CIA is in cover-up mode about its communications with the lawyer implicated in a shady spy operation against President Trump. What is the CIA hiding about its role in this plot against President Trump? We have a hearing scheduled again in May, so next month. So Judge Walton wants this case to proceed after 2 years, 4 documents, heavily redacted. This is the context for this whole FISA fight, right? Who can we trust in the federal government when it comes to spying? Thanks for watching. Don't forget to hit that subscribe button and like our video down below.